Welcome back to the Tomb, everyone. This is Pharaoh Ali, and for today's episode, it's called Better Call Pickles. And I have a very important guest with me today, and I'll have him go ahead and introduce himself, and then we're just going to get into it.
All right, what's up? I'm James, Pickles DiMaggio. That nickname was given to me a long time ago. I'm a different person since then. But I'm Ali's good friend. Some say best friend.
Best friend.
Best friend. And I'm an attorney.
Brother. You're my brother.
Also brother and attorney. I practice civil defense law at a firm up in White Plains, New York. I've been practicing for like four or 5 years. Damn, it's been a long time. But yeah, that's about it.
Okay. Well, first of all, thank you for being here. You said it's your first podcast, so just don't fuck up.
It feels different, man. I can tell why people do this now. There's a feeling in the air.
It's just something in the air. All right, so let's get into it. What made you want to be a lawyer, and how did you decide on the area of law that you decided to subsequently practice?
So that's a loaded question. I remember I actually never thought I would be a lawyer because my father is a lawyer. He's a real estate lawyer. I remember telling him growing up, I will never do what you do. And my dad was like, all right, well, bet. And, as time went on, I went to UMass, obviously, with you, and found out that I suck at science. And I could not do biology, could not do kinesiology. So I then went to economics because I couldn't get into the business school either because of the damn chemistry grades. But as time went on, I learned a little bit more like what my dad did. And he kind of told me a bit about how he liked helping people, especially, people who really needed that you didn't expect it, even family, friends and stuff like that. So eventually I kind of got interested in law, and I always wanted to practice something like sports law or become an agent or some kind of employment law. That was like my big thing, employment law, because I was part of the doorman union when I was growing up. Now, as time goes on, things change. As I try to actually get an internship with the union that I practice for, I found out that they're a little corrupt, with a couple things. I thought I had the perfect resume, perfect cover letter. I used to be a doorman. I get this kind of, labor, would love to learn employment law. And I found out they kind of just gave those internships to like their siblings and stuff like that. So that was kind of cool. But
good old nepotism.
Yes. And when it comes down to it, that's kind of the whole legal world when it comes down to it. But I then interned at this civil defense firm, meaning basically if you get sued personally, so you're not getting sued by a government, or the state, something like that. You're not being sued or prosecuted criminally. I could represent you. That's kind of how it is. You accidentally hurt somebody or purposely hurt somebody, but it doesn't go to, a criminal intent. I interned at this firm that I'm actually still at. And really, I never thought I would like civil defense, but also the firm itself is awesome to me. So, they're not crazy with hours. They're not, and they kind of treat people like human beings, which is nice, which once again, you do not see in the legal world or at a lot of firms. So that's kind of where I'm at now. So I've gotten to civil defense.
Do they normally kind of treat you guys like garbage, like when you first get in, or?
I've heard horror stories. That's why I've been really lucky with where I've been interning. Now I probably have slightly less pay than, the big firms, but the turnover at those firms are crazy. People last months. The two people at my firm that actually, they were my age now when they left my firm after a couple of years, and they took, big law jobs. They went to bigger firms for, a decent amount of a pay raise. Within 6 months, both of them left those firms. They were both out. They were like, we can't deal with like the billable hours. We can't deal with, lawyers being always competitive and trying to like one up and show like why they're better than you. And fortunately, that's just not how it is at my firm. And it's a small firm. So, I'm the youngest by 20 years. So,
Yeah, that is a well-seasoned firm.
yeah.
So you said that because you worked as a doorman and also in the union, that you wanted to work in employment law. So with employment law, what is that? Does that deal with like job discrimination in terms of hiring, firing, and like equal like pay and not getting a promotion and stuff like that?
Yeah, it's a general term. It can range from discrimination or wrongful termination to something where I would have liked to do with the union, which is kind of like negotiate contracts between the property management company and the unions and stuff like that. So every type of law ends up being like all encompassing kind of thing. But yeah, it's a lot of discrimination, a lot of negligent hiring, wrongful termination, people not honoring certain employment statutes like the Family Maternity Leave Act, stuff like that. So it's something I always wanted to get into. I took a lot of classes about it, but when an opportunity comes to get paid, you got to take it. I said when opportunity comes to get paid, you got to take it, especially when you have a decent amount of law school loans.
That's fair. Does it, so I take it employment law would also deal with not being paid in a timely manner?
Yes. I feel like, some people know about that. Some people.
Some people. I don't know who, but yeah, some people might know a little bit about that.
Take a wild guess. Free t-shirt to anybody you can take away.
Yeah, we're gonna start a giveaway. It's like free t-shirt. Who can guess who's had experience? So like you said, it's like there's different like fields of law and things like that. And it's like, so within your opinion, what do you think is probably like the easiest law to practice and vice versa?
Damn, I'm about to call out some of my friends or something.
As long as they're getting paid, fuck them.
I mean, it's true. It's true. I don't know. Is there an easy law to practice? I don't know. I mean, everything takes time to learn. Like, I feel like I wouldn't be able to just like jump into corporate transactions and stuff. Like, I don't know. I can learn it, but it would probably take a little bit of time to learn all those buzzwords and stuff.
Mm-hmm.
But then again, I feel like corporate transactions is probably pretty easy. Any kind of like that corporate stuff, like it kind of just like, it's just a lot of like paperwork and stuff, especially on the lower level. There's only so much you're going to do. It's really just a lot of contract review, document review. That's what a couple of my friends do actually, and they do not enjoy it, but pays damn well. And you can, if you like keep moving up, you start to become kind of like the big swinging dick person. So
fair enough.
It's all there. And I mean, especially like if you want to like those cool jobs, like if you want to work for a ball club, stuff like that. I mean, they're always looking for corporate experience like that, corporate transactions, or some kind of related field. If for any of these, like if you want to work for the Mets and like the business area, they're always looking for that kind of experience, and you get paid well. So
okay, so corporate easiest.
Hardest? Opinion.
What's up?
Just an opinion. It's just an opinion.
Like I said, in your opinion.
Yeah.
But so what would you say is like just, I guess maybe even going through law school and just seeing people like kind of picking where they want to go? It's like, what would you consider like the hardest field?
Oh, I mean, I know that right away, actually. Any kind of like IP and copyright law. It's just extremely hard to get into, like insanely hard, because a lot of people want to do it because that's where like music is. If you want to become an agent, it's all about kind of knowing about IP, copyright, entertainment law. But if you want to do that intellectual property and practice it, you have to take like a whole nother bar itself. So you have to take the one bar to get in to be a lawyer, but then there's a whole nother IP bar, and with that you need to have a science degree background. You need to have graduate, because a lot of the IP stuff is like trying to get certain formulas either copyrighted or patented.
Okay.
So you have to understand why this is different compared to the millions of other kind of formulas.
So if you have a formula and they add like a methyl group, you have to know that adding that methyl group doesn't actually change, like it changes the formula, but it doesn't change like the actual structure of it, depending on where the methyl group is. I'm pulling shit back from undergrad, but
I mean, yeah, say whatever you want, because I don't do IP, so I have no idea. I have no
speaking magic to me.
But yeah, it really is all about just kind of being able to differentiate it, which is why you try to make this thing patented. So whatever laboratory or research group is now hiring that IP lawyer, the IP lawyer needs to then explain it to the patent bar with their application and say, this is why. Here's the legal analysis and here's the scientific analysis, mix it into two. So, and that's why, first of all, it's hard to get into, hard to practice, and it's really exclusive in general. Like very few people are able to do it, and it pays damn well.
Huh?
I think starting salary last time I looked, because I remember thinking that I wanted to do this in law school before I realized how hard it was and that you needed a science background, was like 120, and that's like on the low side.
How much?
120,000 starting.
Starting.
Yeah, starting.
Like entry.
Yeah. Like foot in the door. Here's $120,000. I know.
My biochemistry background and the way I love to argue. Oh, fuck! I missed my calling.
Yeah, you can still go to law school.
I'll catch you in the next go round.
I had some older people in my law school. I had people like in their 40s and 50s.
I mean, yay. I mean, how old? Like, how? I know that there's not like a age limit on how old you can be when you're practicing, but you have to stay relatively sharp as a lawyer. It's like when you start getting older, with some people, the sharpness starts to go. It's like, so.
It's absolutely true. But lawyers practice forever, man. Like the two partners at my firm, they're in their 70s and like, they're not quitting anytime soon. They're still, and they're both sharp, obviously, but
okay.
Yeah, they're not losing it. They're 10 times the lawyer I'll ever be, but lawyers just, I always feel super young with anything I do in the legal area. And I know that including with the clients I talk to, they're always like, are you like 21 maybe? Like, are you an intern? I'm like, no, I've been practicing for 5 years.
Like, I want to speak to a lawyer. You are. No, a real lawyer. It's like, did you just dress up for Halloween?
Like, take the binky out of your mouth, get out of my face, and get me somebody who's 75.
Right. It's like, I need an adult. It's like, I am an adult. But yeah, like you said, is that while you were in law school, you're thinking about like a lot of different things. So I kind of wanted to ask you, is that with like going into law school, what are some like misconceptions that you had, and what are some things that you wish you knew going into law school that once you finished, you're just like, fuck, I really wish I knew that?
Trying to think like exactly. One would have to be probably practicing a little bit more of just being comfortable public speaking, which, I've never been a great public speaker. I've gotten a bit better, but I used to, even just like talking in front of a classroom for like a half a second, because a lot of what they do is just calling on anybody, whatever that method is called, that is completely slipping my mind right now. It's not Plato's method. It's I forget what it is. Some philosopher's method. Where
the Socratic method.
Socratic method. I can't believe I forgot that. But that's just about like 75% of the classes I took did the Socratic method. Of doesn't matter like who raises their hand, they just go, this DiMaggio, give me the background of this case, and you just kind of go and facts, analysis, rule, kind of thing. So that definitely would have helped, because there were times I was straight up shitting my pants, thinking that I was either going to get called or I knew I had to talk in front of the class. Now, eventually you kind of get used to it, but it would have been nice to kind of figure that one out. And honestly, just like probably more organized note taking. That ended up being a huge thing, which obviously it seems so obvious at the time. Like, yeah, law school, you take notes. But it's really more about like organizing those notes. So when you look back at it like 2 days later, you're like, oh, okay, now I know what I was talking about. Instead of like going from page to page and like everything's all jumbled together.
Yeah.
That would be a little bit, that would have helped me a lot, honestly, especially like the first 2 years when I was just like writing random things down in random places. I had a post-it note there, had like something written on a folder here, and just like nothing labeled. I was always jealous of like all the students who like had like everything color coded, and I was like, that's such tryhards, and they ended up being like the best students. So.
Like fucking new fucking nerd. It's like, but
You're trying to understand this.
like, we're just trying to coast. Like, stop bringing up the curve.
Yeah. So I mean, those are probably like the two big things. Obviously, you read like a shit ton in law school, and honestly, reaching out for help like when you need it in law school. That's something that it took me a long time to start talking to kids in law school, to be like, hey, like, do you understand this? Because I have no idea. Or, like, can we share notes? Can we do this kind of thing? That took me a long time to just get comfortable. But then I realized like other people are looking for the same thing. Like they're looking for help any way possible. For the most part, you're gonna have your douches who are not gonna try to help you, because
Yeah,
it
that's
doesn't.
what I'm about to ask. Is like, did you have some of those people in your class that are just like the know-it-alls, where it's just like, hey, can you help us? And it's just like, no.
Yeah, because they knew that they were top of the class or near top of the class, and they're not looking to help. They don't need your help, kind of stuff. I had plenty of those kids who thought they were too good for the school, and very opinionated. But you find a good group of kids who I still obviously talk to, and they helped me throughout. And honestly, you need it. Most of those kids need help. You need to be in a study group. You need to be in some kind of thing. But like the first year, especially because I was part-time on my first year while I was working as a doorman, like I didn't get into a study group for a long time, and I always was a little left out. But I was like, no, I can do this on my own. But then after I started to go full-time, I actually asked for help from kids. I was like, oh, these kids are nice, and maybe I can help you too. Maybe it depends, but
like, hey, do you want to be my friends? I need help.
yeah.
All right, I'm about to expose my whiteness. So in the show that we've watched, Greek,
Yes,
like,
great show.
Great show. ABC Family. One of the characters on there, she ends up going to law school, and like one of the things that they were talking about is like within the study groups is that because of like how much material you would have to read, you would literally just chop up sections to be like, you read this and then explain that to us. And is that kind of how like the study groups worked in the way that you did it?
Yeah, for certain classes, when there was like a ton of reading, definitely. Especially like those more kind of like general ed classes that everybody has to take, when all of a sudden you have like 40 pages of reading for one class to do like the next day. But then, for the other classes, you have another 40 pages each. So I had done that before with some kids, but a lot of what we do too is just kind of going over each case and making sure you knew the rule of the case, because you have to figure out like what the ruling of that case is and how it's applied to that fact scenario. So you have to make sure you get that right, because sometimes you think you have the ruling, but it ends up really being dicta, which means basically like that's just it's not a throwaway sentence by a judge, but that's not the rule that would be applied to say like another case that's similar that you could apply to that fact scenario. It's more, you have to find the exact ruling, and which is usually supported by past case law, and you see like the citations to it.
And that's something I wanted to talk to you about like past case law, because a lot of times the way that well, not a lot of times, the way that the laws are set up is through precedent, where it really relies on what another court has done before. So could you kind of talk about that and how that can kind of perpetuate a certain ruling, and then how hard it is to overturn or get a different ruling, even though it might have a long history of precedent?
Right. Yeah. I'll throw a law school term at you. It's called stare decisis, which is Latin for, I don't know, something about precedent. And I mean, basically, yeah, any kind of fact scenario in a case, you take whatever the rulings have been in the past, 100 cases, and they're everywhere. There's cases for everything. And then you apply it to that fact scenario, and you try to either make it as different from that past case or as similar to that past case. So the United States itself is basically a case law country. Now, that doesn't mean we don't have statutes, obviously, but when it comes to doing a lot of motions, or especially in the pre-trial kind of area, you're always looking for past case law rulings to apply to your case to say whatever ruling you really want. Weirdly enough, the only case law state, I believe, is Louisiana, but they're crazy down there. So like, they don't really go over statutes. It's really just more about past case law, which can go obviously back to the 1800s.
Yeah, that's a slippery slope.
So,
you can almost end up back in slavery if that's
exactly. So Louisiana is kind of crazy, but it does make it hard to either overturn or have a different kind of decision from the past case rulings. So either what you kind of have to hope for is a significant difference in the facts. It seems like it's similar, but like, you can show to the court that there's no way that this rule should apply, or maybe it should be an exception. Or honestly, you get a judge who just doesn't agree with the past case rulings and kind of starts almost setting up new case law. It's kind of happened recently in my area of law of civil defense, of not having to prove comparative negligence for the plaintiff. I don't want to get into like an hour-long boring conversation of civil defense, but basically there was a time where if you could show that the plaintiff was even 5% at comparative fault for, say, a motor vehicle accident, that would preclude him from getting summary judgment on liability, meaning like he can't say that you're 100% liable. They can't make that motion before the case has been heard by a jury. Okay. But now the new case law in New York is, if you can prove that defendant, before this has been heard by a jury, so after depositions and stuff, is liable in some way, you are now granted summary judgment on liability. So no matter what, he will be liable for some kind of portion. And what that does to a jury, at least from the defense side, which is why I disagree with the law, is going into the case
guilty at some extent.
Exactly. The jury now knows that, okay, well, you are liable for something, and it's a bias. So, but that had never been good case law until like 2018, when an appellate judge wrote this decision, basically, and has really changed like that kind of area of law. Basically saying the plaintiff doesn't need to prove that he himself is not liable. He just has to prove the defendant is liable at some point.
Like you said, with that can kind of taint the jury. So wouldn't that kind of go against like the constitutional, like a fair, like like a fair trial?
Well, that's the argument you can make, but that's not how the judge sees it in that case. He's saying that the jury can still find the plaintiff liable for however certain percentage. However, he is somehow liable, whatever percentage the jury. It's more about, well, the jury can figure that out, not that this is going to make an impression on the jury. But that is definitely the argument, and that's the argument I've made in a lot of my motions or oppositions. So far, no luck. I have not made a landmark impression on any judges yet.
Not yet, but don't worry. Like, bounce some of the arguments off of me. We'll get there. We'll get there, and then just put me as a footnote. A little shout out.
Just cite to you. Please call Ali at.
Right here. There you go. No, but that is very interesting, just because it makes sense. Because is the jury told that, like, this person is liable for X amount of X, Y, and Z before, like, even the trial begins, or as they're getting prepped or something like that? Like, are they exposed to that information before they hear either arguments? Either arguments.
They're not exposed to, like, the percentage of liability, because that's what they're there to determine, how much that person is at fault. But they do know that he has to be found liable in some sense, because it has been granted that plaintiff has gotten liability. So
if you have to be found liable,
yeah, but you can find the defendant 20% at fault, plaintiff 80% at fault, but you do have to assign some kind of percentage to the defendant, since he's already been found liable by the court due to the summary judgment.
So even if I go to trial, even if I win, I still lose.
Well, yes. But that's why you fight liability.
You don't lose as much.
You don't lose as much. Now, if you get an 80-20 ruling in your favor, that's pretty good. You got to accept that. Usually it's insurance being paid out anyway, but yeah, I mean, it's definitely the argument, and it's screwed over a lot of defense firms recently.
Yeah, because that makes fucking no sense, because I'd rather just roll the dice and just be like, you know what, either I'd rather be found 100% or 0%, and I better just get some good lawyers, not some Amber Heard lawyers.
Yeah, well, even though I feel like those Amber Heard lawyers cost good money, they're not making their money.
Yeah, they probably charged her a lot, and she should probably hit them, because you're not getting what you paid for. You know, throw some mineral spirits at them.
Some cases are indefensible though, so that's why you just recommend settlement when you see something. But some people are just too stubborn, especially sometimes.
And it's funny that you say that some cases are indefensible, because that's something I kind of wanted to talk to you about. Is that within every profession, well, almost every profession, there are professional ethics that everybody within that profession has to abide by. So are there, like, any things within your professional ethics that you might disagree with, that you still have to abide by, but it's like, it's like, I'm only doing this because I'm obligated to?
Right.
I don't know if you could talk about it, because I don't want to.
I would not be given any actual things that's happened to me, but
because I want to pick up your bag.
I'm trying to think, like, exactly the big thing for lawyers in general is, you always hear about, wow, like, that lawyer definitely knew that either their client was lying or helped them lie, kind of thing. And they always go back to the ethics rules that I cannot think about right now of what they're called. But, like, the first rule or second rule or whatever is zealously advocate for your client. So, what does zealously advocate mean? up to however you want to really define it for the most part. Now, there are ethics rules against lying when you know it's a lie, especially if somebody's in danger, things like that. Fortunately, I really don't have to kind of deal with that portion. But that's why a lot of lawyers that at least I know purposely try to stay as far away from actually knowing or being told what happened and then trying to defend, a certain way that would actually be a lie. So, now how many lawyers do it? You don't know, but I know a decent amount who try. They're basically, they know, but they can always say, I was zealously advocating for my client. And I actually didn't know. I was never explicitly told that. I went with what the evidence showed, and I zealously advocated for him.
That's fair, because if you're like, say if you're defending someone who's accused of murdering someone else, and they were like, yeah, I murdered that person.
Technically,
you have to zealously
advocate, and you have to try to get him the best deal possible, because that's you zealously advocating. But now you're not allowed to know that he killed that person and say, no, he did not kill that person. Now you could try to find a defense around it.
Yeah.
Technically.
Okay. But still, that is protected. That's protected, right? Under like lawyer client type of.
Yeah. No, that's absolutely a thing. Attorney-client privilege is absolutely a thing. And you cannot talk about it. But that's why it's just a very fine line of zealously advocating and straight up lying.
Because the thing is that if you're a really good lawyer, you can get that person off. But it's like, that person is guilty, but you were just able to get them off. So that's because I've had to talk about this with I think I told you about this with one of my friends, that there was a difference between professional ethics and societal ethics. Because I know that when Hillary Clinton ran for president, when she ran for president, is that people went and looked at her. It was Hillary Clinton. Looked at her like track record, and her being, I think it was a defense lawyer. It's just like she defended someone who, this is gonna be on YouTube, who was inappropriate with children. Yeah, that's the best way I can do it without the buzzwords.
Good job.
And when people looked at like the tactics that she was using, it was the same tactics that like social groups advocate against. It's just like you're victim to like blame and everything like that. And there were people on both sides that are pretty much saying it's like she was just doing her job. But then societal ethics will just be like, yeah, but the way that in which she did her job, society wouldn't agree with, but it was nothing ethically wrong within her profession.
Mm-hmm. Yeah, I mean, that's definitely a thing. And to a lesser extent, it happens, say like when people represent themselves without an attorney, either they can't find one or they feel like they can represent themselves, rightfully. And all of a sudden they start the case, and it seems like things that say the other side is entitled to, societal rules or norms, you're like, why would you need that? Or like, why request that? Why do you think that way? But when it comes to the law, it's what you're entitled to. I've had cases that specifically they're called pro se plaintiffs, meaning that they don't have a lawyer representing them, and they get into fights with me. They're like, first of all, because they don't understand the legal sense, but also because they really do feel like they've been wronged, and I'm asking all of a sudden for their tax returns. And I'm like, I'm entitled to it. I don't know what to tell you. I'm allowed to see your tax returns for this case, for this matter. I'm allowed to see medical records if you're going to bring this claim. But I mean, I've told you about a certain case, and I can't get like super into it overall, but it's a woman representing herself, and she believes she's in the right. I obviously have to zealously advocate for my client and say that I'm not liable, and she gets very upset with that, and she thinks that I'm purposely misleading. But when it comes down to the letter of the law, it's what I'm entitled to, and I have to zealously advocate. Now, if she says that's what's been going on in that case, probably to any other person who's not an attorney, they're going to think that I'm like harassing her or, trying to purposely, make it hard for her. But first of all, I'm supposed to make it hard for you. Second,
that is your job.
It's the rules. Now, it might not be the societal rules. It feels weird to be giving up personal information, especially to another side that is trying to say you're wrong, I'm right. But that's things like basic discovery. So that's a big thing, like discovery rules compared to, say, societal norms. When you're like, why would that person be entitled to that? I feel like that's a big difference.
That's what I want, and that's what I wanted to get into. Is I'm happy that you brought up discovery. Is that so? You said basic discovery. For those of us who are not in the upper echelon of being a lawyer, could you describe what basic discovery is and what that entails?
Well, I mean, say for specifically my kind of law, my area of law, since a lot of it has to do with personal injury, it's these first kind of discovery demands get sent out where it's like, okay, you have to give us any witness information, medical records and authorizations, because if you're alleging a personal injury, you have to give up your medical records, any kind of statements you've made in the past regarding this incident, photographs, if it's a motor vehicle accident, repair estimates. So it's a lot of, say, paper discovery. So it's basically everything where they're like, this is my claim and here's the evidence to back it up, kind of that paper evidence to back it up. And that's kind of how you get the ball rolling. It's completely different when it comes to criminal law. And, it's been so long since I've even looked at it, but what prosecutors have to give to the defense, they have to give exculpatory evidence over. Now, when they have to, that's what they always fight about.
And exculpatory evidence meaning?
Evidence that could possibly show that that person is innocent or lessen the sentence, lessen the punishment, not the sentence. Sentencing is different.
So pretty much what Kamala Harris wasn't doing.
Bingo.
Gotcha.
So that's basic discovery.
So for you as a lawyer, is that just taking that just one part of like criminal discovery? It's like, do you think that is something that should be like automatically like mandated, and that if it's found that the attorney did not hand that evidence over in a timely manner, I honestly think that they should be disbarred and possibly face criminal charges, because I think that if you are purposely misleading the court or purposely withholding evidence, it's just like, and that person ends up going to jail for it, however long they served, you serve. Because those are years that you have taken away from them based off of the nefarious activity that you've done.
Right. Yeah. I mean, I could definitely see that side of the argument of, you should be automatically disbarred. Now, it just like everything I would say in law, everything is not just general and overranging. Every kind of case is like a snowflake. Every one of them is different. I'm just but so now I do think they should probably go up to a bar committee or a grievance committee if something like that happens. And obviously they should also be allowed to defend themselves as much as possible. But also, it kind of, for prosecutors, civil defense is a little different, I also feel it's not as heavy, nobody's going to jail in civil defense, where it's more what insurance money does that person get.
Yeah. Or financial, it's more like payouts than.
Yeah. It's now it can still affect your life, but it does not affect your life, say, you going to jail wrongfully. So I could definitely see something like a grievance committee if something like that happens. But at the same time, for prosecutors and DA offices, it's so competitive in those offices, and it's not just that one prosecutor, it's the entire office, and it kind of goes from the top down. So it's them trying to get ahead sometimes, or they're saying, well, this is how I was taught, or I truly didn't believe that this was exculpatory, from my other past cases. So the rot starts at the top for certain things like that.
Yeah, and I feel like, I think that's the double-edged sword of law, is that it's the gray area is there so that it's like there's some nuance to it. But then I think also, like you said, is that some attorney can say it's just like, oh, well, I didn't think it was exculpatory. It's just like, that's where you start abusing the gray area, because it's like vague, I'm going off of this, and it's like stuff like that. And it's just like, I think there needs to be, to an extent, a clear-cut rule. It's just like any new type of evidence that you have, whether it be big or small, both sides need to have it. Because I think that when you leave it up to the prosecution to turn it over, they're gonna wait until the last possible second, so that the defense can be taken off guard and be like, oh, it's like we need to have a motion to extend, I don't know, what's the legal term for it? It's for just like a rainy day, a rain check.
You basically got motion to extend or adjourn. Yeah.
Okay, there you go. See, I'm learning. But yeah, I think that especially because conviction rates play into job performance, how they're measured as a prosecutor, is that it's gonna lead people to do nefarious things.
Right. Yeah, it's a balancing act for that stuff, because it's absolutely true. You definitely, within DA offices, it's about conviction rate and who you put away, how many people you've put away. It's a competition, because that's how you get ahead, and that's how, when you first start out as a prosecutor, you're not getting paid particularly well, honestly. But if you move up, you can start to be paid better, but also all of a sudden now you have more job opportunities where you finally get the big payday after being in a prosecutor's office. That's every attorney, like big attorney that's made a ton of money, always ends up, either being in a prosecutor's office or actually starting at legal aid, stuff like that, because that's where you really learn how to fight in the court and everything. But every single one, that's the partners in my firm. The one guy started at the Bronx DA's office. The other guy started at legal aid in the Bronx. And now they're partners. So it's a balancing act, and they say justice is blind, but juries aren't. So zing, dude, zing. Just a little tidbit for you.
Hey, just say that one more time. Just one more time.
Justice is blind, but juries aren't.
There you go.
Drop it.
Drop the mic. Yeah, because it is very. I feel like when you have the conviction rates as a factor that plays into your job performance, and maybe a little bit societally looking at it, is that, oh, you didn't convict. Say if you have a 60% conviction rate, it's not that 40% of people were innocent. You just 40% of people got away. And I feel like that's kind of the sentiment, is that everyone that goes there did something. Kind of going back to the liability thing, it's just if you're here, you're some way you're liable.
Right. And for them, it takes a lot to bring those charges. I mean, it does take a while. You don't just automatically bring charges. They're doing a whole investigation, well, usually.
When you look like this, the charges come fast.
But with that comes an investigation, and that's actually how sometimes people get off, because the investigation is bad or something like that. But they do a whole investigation prior, and they say, okay, can we bring these charges? They go to their boss, their boss's boss, and say, I want to bring these charges. And it's almost like their baby, right? They're like, this is my case. I've worked really hard on this to show that this person is guilty, and now I can bring it to the jury. And then I have to fight again for it. So they're going to do anything they can because they really think that person's guilty, usually. Right or wrong if they think that person's guilty. But that's kind of where this like conviction rate comes from, because it's not just like, oh, this person might have, they're like, no, my investigation shows this person committed this crime. Now I'm going to bring it to the jury and show it.
That's the thing, is that what I've seen is that even if the person didn't commit the crime that brought them in, what they were arrested for, they will still just not even dismiss it. They'll just bump it down to a lesser one and just say like, oh, well, you can take this and then just go home. Right. Or if you want to push this to trial, then I will push it up to here. And it's just like, and that's pretty much like the strong arming of the prosecution's power, is that they can pretty much say to you, we can go to trial and you're facing maybe 25 years, or you can take this lesser charge, do 5 years and then go home. And the person still might be innocent. Right. But saying that and presenting that to them, no one wants to roll the dice on 25 years.
Yeah. And especially, juries are completely random. Like, you can't trust them. They bring biases even though they're not biases. They judge people when you're not supposed to judge people. They take things that they're not supposed to consider and completely consider it in these kinds of cases. It completely happens, which is why a lot of people don't want to risk going to trial. Now, for the prosecutors, obviously, depending on the case, they don't want to risk having that person get off, but at the same time, it's not as big of a deal for them. If you get off, you get off. But for a person who's facing 25 to life and maybe was at the, might look somewhat guilty, he knows he might look guilty, but he didn't do it. Why take that chance? Depending on how the prosecutor is and how that jury is, especially it all depends on different kinds of counties and stuff like that. Some people are more, they more side with somebody who's being charged, but then, in more conservative areas, they're like, no, we support our prosecutors and police. So always depends. It happens civil defense stuff too. That's why we try to settle cases in certain counties, because we know we'll give them way more than we would ever give them. So it's stuff like that.
You say settle in certain counties. Do you have a certain amount of leeway in where like the case can be heard in terms of counties, or is it just where the accident or like where the incident happened, if it's in that county, that district will hear, well, that court will hear you?
Yeah, it kind of depends for certain things. For civil cases, there's it's called like a venue of which court should hear it. And there's different ways to get into that venue, or at least for civil cases. It's either a party to the action lives in that venue, say like Bronx County, either a plaintiff or a defendant live there, or the accident happened there. You can now bring it in that case. So that's sometimes, you almost do like a venue shopping. If you're a plaintiff and you're going to try to get as much money as possible, you go to a more plaintiff-friendly county or venue if you have that opportunity. If the person is from the Bronx, the accident happened in Orange County, and the defendant is from Greene County, he's going to bring it in Bronx County because Bronx County is more favorable for plaintiffs. So it's kind of how you got to go about it.
Okay,
If
so
you have that option.
excuse me.
If you have that option.
Okay, yeah, because it's seems like there's a little bit of a science behind it. Like, I know there's definitely a science behind selecting jury members, and then also just how you show up to court.
Mhm.
So like I found out if you're wearing glasses, you're more likely to get off because the jury thinks like, oh, this nerd couldn't have done it. It's just like,
It's all about presenting yourself to the jury, even though they're really only supposed to consider evidence and testimony and stuff like that, not how somebody looks. But I was on a jury in Queens where a guy stole this woman's cell phone and he jumped a couple other people. And after the case, which ended up being a mistrial because the jury foreperson was posting on social media and getting opinions that way, the one guy who ended up wanting to side with the defendant went to the prosecutor came after and was like, do you mind if I just ask you a couple questions about the case? Because you're allowed to do that, after the case is either decided or a mistrial. So he was talking just about like how he was going about the case. And the one guy was like, I just don't understand what you were doing with your hands the whole time. You kept doing this. What is that? And I was like, that's not relevant at all to the case. But he definitely considered that and was like, I don't like this guy. And was going to side with the defendant. It was actually it was a hung jury for like the first 2 hours until they declared a mistrial. Guy was going to get off, I think. Yeah.
And we might as well start getting into it because I know when I post this, especially with the topic of it and what's going on right now, we'll just get into it. I feel like that is kind of what is happening in the Johnny Depp and Amber Heard case. Well, first of all, fuck her. If anyone disagrees with that, you can stop the podcast right now. Fuck you.
They're not watching.
From the evidence, she's awful. But then also is that she has lawyers that aren't charismatic, that aren't likable, that when they're talking to the judge or other witnesses, they are very rude, abrasive, and at some points just harassing. And if I was her, I would probably tell them to chill the fuck out because you're making us look bad.
Right.
Because whether or not she could have all the evidence in the world, but if, like you said, depending on how your lawyers present the case, doing shit with their hands or the way that they talk, you can fuck it up.
I mean, completely. And I mean, we see it in the news now from this case and just how horribly this whole case has looked for her and how poorly she comes off, how poorly these like lawyers come off. And now a little bit has to do with the evidence, but also
not helping her.
Also like how they've presented themselves in general, they come off looking stupid with, not knowing certain rules and everything. And that's absolutely going to influence the jury's decision on this. The fact that they haven't settled this case is crazy, but at the same time, maybe Johnny Depp wouldn't take a settlement. He's like, I know that I'm going to kill this case. Or, you got to come up with a number that's going to wow us all and somehow, restore my reputation.
And I think part of the reason why he wouldn't settle and petition for it to be live stream is so that people can see with their own eyes what happened. And people in a PR team, like Heard's PR team, can't control what information comes out of the courtroom, because everyone can sit there and look at it and be like, oh no, we heard the fact that we heard Heard say is that she pretty much said to him, it's just like, tell them it was a fair fight. Go and tell the jury and the judge that you, Johnny Depp, a man, the victim of domestic violence, and see how many people believe or support you.
Right. I mean, it looks horrible for her. So
I don't know how you can come back from that.
I don't think you can at all. It was a great move by him to bring the case. You know, if he actually didn't want to settle, or he said, you know, you're not going to come up with a number big enough for me to settle this case, another great move if you know it's all going to back you up. And honestly, Depp's lawyers have been really good too. So it's one of those just insane cases that, you know, once in a lifetime kind of cases where, especially now with like social media, where you get things within 2 seconds.
Yeah.
And now hundreds of thousands of people can be talking about you, and it makes it even more on another level. It's crazy. She's completely ruined her reputation.
Oh, without a doubt. And I think that this is, without having to go to a newspaper, this is Johnny Depp's op-ed. This is his response to, it's like, oh, you're gonna go and tell the world that
Right.
this happened?
Right.
I'll do the same thing, but it's going to be in a legal sense, so everyone can see that I'm going to be. I hope that he is validated.
Yeah. Yeah, this isn't just his story. He's like, here's my story. Here's the evidence to back it up, not just an article.
Yes. So I think it has been a very interesting case. I think if they're not talking about it now, they're definitely going to be talking about it in law schools.
I think so for sure, especially in for like defamation cases and stuff like that. I don't know how they wouldn't be in law school textbooks or in law school classes. It's a great case for it.
Yeah.
Even evidence, the whole hearsay, clips from that can now be shown that he expected those hearsay objections. Very impressive.
And I think that the way that is going to be very interesting for defamation cases is because the argument that Heard's team is trying to make is that they did not specifically name Johnny Depp. His name did not show up. So it can't be defamation if she didn't say he's the one that did this. However, I was listening to today when they were, there was a motion to dismiss. So I guess his team had to defend it. In Virginia, defamation doesn't have to be direct. It can be indirect as well. Like, so if she says, oh, I've been dealing with domestic abuse from my husband.
Right.
You only have one husband.
Right.
Like, unless you're a Mormon. Like, so we know who you're talking about. Mm-hmm. Like, so it's going to be very, very interesting in how this plays out. And I think the funniest thing I saw from the fucking case is when Heard's lawyer objected himself.
He's either nervous or thought he was doing something clever, and I don't know what you would object to yourself to. You could withdraw the question,
but they're just stuck on repeat at this point. It's just ask a question, person starts talking, objection, Your Honor, hearsay. But and then you couldn't see the judge's face, but you could hear how her face looks like you asked the question.
Right.
Oh, it is awesome. But I wanted to talk to you in terms of like the future of like court cases and things like that. Do you think that more cases should be televised?
I mean, it's definitely been like probably a question since television obviously has been invented. And yeah, I believe it's always up to the judge for it to be televised. So obviously like big cases like this, so the judge probably sees like a benefit for it being televised, trying to show a good case, and people want to know about it. The only thing that I could think of for why certain trials should not be televised is honestly social media now, because um you can take clips, or you can have like opinions by people who know nothing or know nothing about the case, and have it influence things kind of when they don't know everything. And as much as the jury is not supposed to take that into account, you are not allowed on social media, you're not allowed to talk about it on social media, that whole thing. You can take phones away, but you probably know, unless the jury is sequestered, where they're with like the OJ case, when like they literally had to like live in a hotel with no TV, nothing like that. They're probably going to allow that to influence their decision when it comes down.
That's what I was going to ask, is that how does a court enforce no social media and everything like that? And so like,
I mean, you say it, the judge says it in the beginning. Like with that case I was a jury on, he said it. He's like, you cannot post on social media. You cannot take outside opinions. You are not allowed to discuss this case with anybody except the jury members. But it had to be declared a mistrial because the jury foreperson was talking on Facebook about it and getting opinions from people. So the only reason that they found out about that is because she was friends with a prosecutor from Brooklyn. That prosecutor saw it on Facebook and immediately went to the Queen's Court and was like, "This can't do this." So a little bit of a rat move, but she respected the office.
Snitch.
Yeah, but
I mean, but yeah,
you can't.
They're not friends. I can tell you, they are not friends anymore.
Yeah, no, cannot do that. But the only way to do that would be to sequester. Mm-hmm. And sequestering is something that like it's for like extreme cases, so it's kind of hard. So that's why I'm not probably could see why judges would say I don't want this televised, or I want to close the room kind of thing, because especially because you can just clip so many things and have so many opinions now. It's not just in the newspapers. The news is Twitter, the news is Instagram, stuff like that, and things can go viral from somebody that has no idea what they're talking about. So, or an opinion that is misleading or not based in fact.
So I think that maybe and I agree with you. I think that maybe high profile cases should be televised, and if a judge allows having, just normal cases be video recorded, because I think that I'll start with the bigger one first. I think that in the terms of a high profile case, like in the Amber Heard case, her indictment of Johnny Depp was so loud that his validation needs to be just as loud.
Right.
Like, so it needs to be proportional. So it's like if someone comes out, like if a man comes out and says just like, my wife was abusing me, and it's like, let's say, I don't know, let's pick a wild state. Let's say Samuel Jackson came out and said that his wife was physically abusing him, mm-hmm. and they ended up having to go to court. That should be public, like that should be televised, because you put it out in the public domain, and you're not just a normal Joe Schmo person that posted on Facebook and all your friends were like, this is wild. It is international news. So you need to have it be televised so that whether or not you're found guilty, non-guilty, anything like that, the public stays informed and is not just running, because let's be honest, people don't read nowadays.
No, they don't, or they don't read the right things.
They read things that keep them in their echo chamber.
Right.
Versus you're watching something live streamed and it's just like, well, I don't agree with what he said. It's just like, well, that's the facts. It's like, even though you might be on the side of, well, I think majority of people are on the side of domestic violence victims. I don't know anyone, like, unless they're the perpetrators, most people are on the side of it. It's just like, yeah, don't do that. But with people that are on that side, it's just like you can't look at everything that's presented and still follow behind her, because at some point the evidence becomes so overwhelming that it's like, did he scream at her? Sometimes, but unless being in an argument with your spouse has now become illegal,
Right.
I think that if it's like, I think, and you can correct me, maybe you know the statute, it's like with abuse, I think more so if it's one-sided.
Usually.
It's like, I'm yelling at you, I'm making you feel bad, da, 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 da. If we're going back and forth, that's a bad fight in a toxic relationship. But then if you elevate it to a point of physical harm, then it's just like, yeah, I'm not doing that. It's just like, we can scream at each other, we can do everything like that. And it's just like freshman year, we had a friend. She and I would get into some scream matches with one another.
Yeah.
Was that abuse?
No, probably not. Especially, I mean, if it didn't emotionally damage him.
Don't put that caveat in there.
Might need to delete that part.
No, it's fine, because I'll just say that it's like this. I think with this case, one of the things that us as a society need to look at is that there is a difference between an argument between spouses and abuse. If two people like wear like sailors, that's normal for them. So if they're in an argument and someone's just like, oh, you fucking idiot, that's different than in like maybe a more so Christian household where they don't swear and the husband is screaming to the wife, you fucking idiot, like, it's like, that's different. So it's like,
yeah, it's something you have to take into account.
Yeah. And from things that I've read and everything like that, and it's just like, a lot of people have, well, not a lot of people, but I've seen people say that, oh, well, he yelled at her and da 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 da. It's just like, he could have just walked away. And it's just like, you obviously have not been following the case, because he said straight up, I would try to walk away, she would follow me. That's how he got kicked in the head with the door. And then also, when he would try to walk away, she would emotionally manipulate him to stay.
Right.
What do you do with that?
Yeah, I mean, it's, you know, and if it was vice versa, people would be going crazy too, you know? Be like, he emotionally manipulated me or wouldn't allow me to leave. Yeah. Both ways.
I think that, I just think that, I'm diving in.
Careful now.
Yeah, like, no, fuck it. If I'm on thin ice, I might as well tap dance. No, I just think that the history of domestic violence has been portrayed through the lens of man to woman. Because of the society that we live in, men are impenetrable beings that can never be hurt. We don't have emotions, da, 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 so we can't be abused. But women are delicate flowers that even the slightest wind is like, you're a monster. So I think that when we look at these types of things, like, we need to understand, it's just like, yes, unless you're dating Ronda Rousey, you're not gonna probably have physical marks from your girl hitting you.
Right.
For the most part.
Right.
Now, those emotional types of scars and things like that, those are the things that are more dangerous than any physical scar that you can ever get. It's like, so I think that that's something that we as a society should talk about. We went down a really bad rabbit hole with this one. It's like, we're real far from the law. I'll probably have someone on to talk about this. I need to find someone who can talk about it without getting triggered.
Maybe like psychologist or something.
Just slowly walk off screen. It's just like he's just talking to himself at this point. Okay, let's end on a lighter note. In law school, what was your favorite class?
Oh man, great segue. That was perfection.
Thank you.
Damn, favorite class. I did really enjoy trial advocacy. It's called trial ad. That's basically where you learn the ins and outs of a trial. When it comes down to it. So like, you learn how to do an opening, a closing, direct examination, cross-examination, how to look at evidence and present it, and how to get certain things into evidence. So I always thought that was actually a pretty fun class for the most part. And weirdly enough, like the sport classes that I took, something like intro to sports law ended up being, unfortunately, it wasn't taught by the most engaging person. And I thought this was going to be a great class and this is what I want to do. And that ended up being like one of the worst classes I took. It was like a relatively easy class, but I feel like I didn't learn that much, and it was taught by somebody who didn't really know how to teach. He had the job. He had a great job within that industry, but not everybody's a teacher.
Yeah, especially going to UMass and going to our college.
To a university
in an established
Northeast area
institution of higher learning. I have met some teachers that are brilliant. I've looked at the work that they've done, brilliant. But in terms of conveying that to other people, they're awful. They are probably one of the worst people. Like, they shouldn't be teaching, but the university tells them, it's just like, well, if you're doing research here, you have to teach.
Right.
It's just like, they need to take like a teacher aptitude test. Just like, if you score low, stay at the bench. Stay at the bench and just like work at the bench and hire someone who can actually teach people.
Yeah, it's absolutely true. I mean, I did not like this class that I took in law school, federal tax. It's called federal tax. Like, obviously,
that sounds mind-numbing.
Yeah, but when it came to actually learning the material, since she was such a good professor, this woman, Bridget Crawford, she's one of the best professors of all time, made it engaging, and you were able to learn, and somehow made it somewhat interesting. And I did not hate that class, and I knew she was a good professor and everything. So it really absolutely depends on the professor. You would think Fed Tax would be like my least favorite class, and it wasn't. One of my least favorite classes ended up being the class I thought was going to be like the best class ever. So yeah, so it really depends on the professor, but yeah, that was my favorite class. What did I say my favorite class was? Oh, trial ad.
Yeah,
that was fun, and it was different, so that was kind of cool.
So I know that you spoke about it in terms of what things you wish you knew coming into law school. So for people that are thinking of going into law school or might be in their first year, what advice would you give them going into while they're in law school and preparing for it, in terms of taking the LSAT
to get into law school?
Yeah. So let's flip the LSAT. What advice you would give people, and then your first year, what are some advice? What advice would you give people?
Okay, stuff for LSAT. Well, first of all, it doesn't matter what your major is. Don't do pre-law if you don't want to do pre-law. That's all bullshit. Like, just they'll take whatever you are as long as you get good grades. Doesn't matter. For an LSAT, definitely take a class. Kaplan does. I think I took Kaplan, Themis, stuff like that, because it's more about learning how to answer the question and what to look for than just like looking at the answer and hoping you could figure out what's right. It's a strategy in figuring out how to answer those questions. Like they have like logic games and stuff, and there's certain patterns that you have to recognize, and you will if you take a class that teaches you and you do it over and over again.
So it doesn't have anything. There's no law, nothing,
Nothing, man.
nothing. It's
Nothing.
literally just kind of logic, reasoning,
Mhm.
any math.
I mean, maybe a little bit with the logic games, but for the most part, no math.
Oh, okay. So it's just,
No, it's nothing. It's not, and the law school will teach you the law. And honestly, even after law school, you're gonna have to learn all those laws because there's millions of laws. I learned nothing in law school for the most part about what I currently practice, like with the major statutes, laws, and case law that I currently do. I had no idea from law school because it's a very specific area of law. It's not general for the most
okay.
part. I knew a couple things, but the more you become a lawyer, the more you're constantly learning. Honestly, all I do is bother the other attorneys at my office, asking them questions about what I should do when it comes down to it.
Well, would you agree with this statement? Is that law school teaches you the law, but when you get a job, you learn how to practice it.
Yeah, I would agree with that statement. And I also feel like law school teaches you how to approach being a lawyer, about being prepared, obviously kind of talking in public and stuff like that. And it's about learning the process of being an attorney, I would say.
Okay. And for the first years?
First year, I would say don't burn yourself out. Like it happened. A couple kids that I went to school with, they burned themselves out within the first year, where you definitely have to work. You have to put the time in. But some people like are so in their head about like needing to know every single thing, or honestly having no life. It's true you don't have that much of a life, but like you have to give yourself time to relax, or like you're not going to process things after a while. You can't read 60 pages in a night of very dense old case law. You got to give yourself time, and if you get things wrong, you get things wrong. It's really, as long as you're prepared, especially for tests and stuff, you'll be okay. But you don't need to be, you're not going to be the top student. That top student, or unless you're that top student, who probably, when it comes down to it, they're always going to be the top student. You can get yourself to a good level and be prepared, but you're not going to be able to compete with these kids who are just like freaking. It's either what they're meant to do, or they're just really good at law school, man. Like,
Yeah.
but you can still be a good attorney. You can still be a good student and still be successful, but you can't burn yourself out, especially the first year, man. You still got another 2 years of hating your life for the most part.
Oh, so it's 3 years?
3 years.
Oh.
Usually.
Fair enough. So have you seen some people that were great in law school, and then when they get out to the real world, it's like, you could just say yes or no.
Yes. I can't start like calling people out, but
yeah,
yes.
yeah.
Or
Obviously not, and I'm not speaking like specifically to your cohort. I'm just saying in terms of just being in law school, you're seeing different classes and everything like that go through.
I have seen kids not be successful, or some of the top students don't pass the bar on the first time. But like famous people have not passed the bar on the first time. Like JFK failed the bar. I'm pretty sure JFK. An insane amount of
failed the bar, and now she's doing some backdoor way to get her law degree.
I mean, that's what I'm saying. Like, it's just
an apprenticeship, like an apprenticeship.
Right, through the apprenticeship. But if you look it up, there are very, very famous attorneys who have failed the bar. So the first time around, or honestly, multiple times. But yeah, so it's you do see it. You see it.
Okay. And so that was for our lawyers, potential lawyers. And now for the people that they might be defending, what is some of the, like, because I think we've talked about it before, is that like what advice would you give someone, like if they have to go through the legal system, whether or not they do get a lawyer, they might get a lawyer, so like, but let's say like deposition.
Mhm.
Like some of those can be a cakewalk and then others can be hell on earth.
Right.
So if someone was trying to get ready for a deposition, what is some like simple things that you can tell them that might not be a catch-all, but like it can generally apply?
Mhm. Well, something like I tell my clients, I go over, a certain set of rules basically every time, where it's more about strategies and answering questions and stuff. So I always tell them, keep your answers short. Do not go on a tangent and tell your story, because you want to get the story out. Oh, this is exactly how it happened. But the shorter the answer, the better. And it's really about trying to make the attorney do the work. Do not do the work for them. Because what they can do with a long winding answer is either they can now ask more questions because maybe you gave them something that they didn't think about before. Oh, now I can ask a question about that. Or they can twist words when it comes to later in the deposition. Because the more you talk, the more likely you're either going to stumble over your words or mean to say something one way, but it can certainly be taken another way. So the example I always give is if the attorney asks, what color was the car you were driving? You would just answer red if it was red. And then but what you don't say is a red 2015 Toyota. They didn't ask you the year. They didn't ask you what kind of car. They asked you the color. So that's like a big example I give. The shorter, the better. And that also means the quicker you're done with the deposition, because I'm sure you want to get out too when it comes down to it. And I always don't ever guess during the deposition. It's either you know it or you don't. It's okay to say I don't know. If you don't know, you don't know. But if you start guessing or yeah, I think that kind of stuff, well, now that's going to give them even more ammo, say at a trial, and
Like,
say,
oh, well, you don't know.
well,
There's room for this.
what do you mean you don't know now? You said during the deposition that it was this, or you change your answer because maybe you now remembered it a certain way. And then it's a very easy thing to say to the jury. And a lot of attorneys say, well, this answer, that's different from your answer now. So are you one of those people whose memories get better with time and now you remember the right answer? And it's like an easy, like, all right, go fuck yourself to the jury. So
is it better to say I don't recall? So if you do have to go to trial, so like if you say you don't recall in the deposition, can you then recall in the trial? Or if you say in the deposition, they'll be like, well, you said you didn't recall, right? Essentially what you said is like your memory gets better.
Right. And so it's certainly, you can do it both ways. But usually by that time you can say something like, I've reviewed documents. I'm a little bit better prepared today. So that's what it is. But yeah, usually if you can't recall, you can't recall. And when it comes down to it, it's not the biggest deal for the most part.
Okay. And that is very, well, of course it is good advice because you're giving it. Because a lot of times it's that when attorneys ask like a yes or no question, people want to answer binary, but then also want to give context to it. So I guess my question is that is there an opportunity for like, should a person give context to something if the answer is no, but not like 100% no? Like you can see where that attorney is trying to lead you down, and you're trying to get in front of it. It's just like, I know what you're about to ask. No, however, da 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 da.
Right. And for stuff like that, it's really easy to want to say no and then try to explain yourself. But the attorney asked you a yes or no question. So all he has to say is, I'm going to object to the non-responsive portions of the answer. And now that explanation will not come into the trial because that was not an answer to the question that was being asked. So yes or no, this, and then you say no, but the question was yes or no.
Okay, so what the jury might see is just the no and not the context.
Right. So yeah, and I will always go with the shorter the better, and make the attorney do the work, because you can make it seem somewhat either cloudy, or by making the attorney do the work, it looks like maybe it's not as open and shut case as other people think it is.
Okay. And if anybody's looking for a little bit of comedy, look at Lil Wayne's deposition. It is straight gold.
That is gold. That is gold. I remember watching that. And a lot of people don't like Barstool, but the deposition testimony from Dave Portnoy and Smitty from Barstool when Michael Rappaport sued them is quite possibly the funniest things I've ever seen in my life, because he sued them for defamation, and it was a just fantastic recorded deposition testimony. It's like my favorite thing to watch.
You know what happened with that case?
It got thrown out.
Oh,
Yeah.
okay.
Yeah, he couldn't prove it.
So defamation cases are hard to prove unless they say like
they can be,
this
especially
person,
when you're a public figure or in the media, which Barstool and Michael Rappaport was or were at that time.
and then I'll say this, and then I think, yeah, we've been talking for a little bit, so I'll wrap it up. I won't keep you too long. Is that I feel like with defamation cases, depending on what is accused, it's hard to prove a negative.
Right.
So it's just like if they say like, oh, this person hit me, how do you prove I didn't hit them?
Yeah,
it's hard to prove. It's hard to prove something didn't happen. It's just like the burden should fall on the person that says that, hey, like you said I did this, now you have to prove it, versus me proving that I didn't do it.
Well, that's where the burden usually lies.
Is it?
Yeah, like say if you bring the case.
But with Johnny Depp, he's bringing the defamation case against Amber Heard. So with her, she has to prove that.
No. Johnny Depp has to prove that case. He's got the burden.
So
he has the case. He has the burden.
So he has to prove that he didn't hit her.
Basically, yes.
That
she defamed. It's really more about her defaming him by writing this, which was a lie. So.
And I mean, shit, in terms of defamation cases, yeah, they're doing it. Like his team is doing it because
doing it pretty well.
It's more so showing it's just like he wasn't the abuser in it, she was.
Right. Yeah.
And I think the bar though, the margin of error is so small that like if he does anything that can be perceived as violent, then they'll say that's abuse, so it needs to be thrown out. It's just like, but someone reaching their breaking point versus someone having a continuous history of just doing these things to this person, it's just like, so one incident makes it abuse.
Right.
One incident makes it like X, Y, and Z. It's just like, in certain cases, yes, I think that especially with this case, it's like like you said, it's going to be talked about in law schools. It's going to be talked about with scholars for a while.
For sure.
And it's not going to be on Amber Heard's side. It's going to be more so about what Johnny Depp's team did right.
Yeah. They've been
like they're gonna write a book of what to do based off of Johnny Depp's and what not to do.
do not object to your own question in front of a jury.
Jesus.
Insane.
That's there's so many highlights from it. But so at this point, I just want to give you 30 seconds. If you have anything that's going on or anything that you want to promote, anything coming up, it's like now's your chance.
Yeah, check my SoundCloud. Got a couple bars up
DJ
there.
Pickles.
I never have anything to promote, man. I don't tweet or anything like that. If you're in New York and you have a personal injury case, feel free to look up Wilson, Babe, Convoy, Cuzza, and Cousins. Some of the firm I work at, they're good attorneys there, and we do defense and plaintiff. Other than that, just be a good person, and usually nothing matters. Sign off like that.
Okay. Well, everyone, that has been another episode of Toon Talks with the Pharaoh. I will see you guys next week or whenever I drop another episode.